John Marshall was born on September 24, 1755, near Germantown, Virginia. He was the first of 15 children born to Thomas Marshall and Mary Keith. When Marshall was a child, he was mainly homeschooled by his father. However, he did spend 1 year at Campbell Academy in Westmoreland County with future U.S. President James Monroe as his classmate. In 1780, Marshall studied law at the College of William and Mary in Williamsburg, Virginia. In 1801, the position of Chief Justice opened up in the Supreme Court, and President John Adams appointed John Marshall. Marshall went on to serve in the position for 34 years. He transformed the Supreme Court in many ways by turning it into a strong and equal third branch of the U.S. government. John Marshall ruled on the landmark cases of Marbury v. Madison and Cohens v. Virginia.
The landmark Supreme Court case United States v. New York Times occurred in 1971. This case concerned the New York Times printing an article which exposed the government from hiding the truth from the public about what really happened when the United States had went to war with Vietnam. Daniel Ellsberg is the man responsible for finding out what had really happened in Vietnam. He found the information in the Pentagon Papers and immediately made copies and delivered it to the New York Times. He did this because he felt that the public had a right to know what had really happened when the United States had went to war with Vietnam. Word had spread, and President Nixon became aware of the fact that the New York Times was publishing articles about the government's secrecy. President Nixon didn't want this information getting out, so as a result, he ordered a prior restraint on publications concerning information which was held within the Pentagon Papers. This case went to the Supreme Court after President Nixon ordered a prior restraint, also adding that the publication of these articles would threaten the national security of the United States. The New York Times argued that ordering a prior restraint was a violation of their company's First Amendment right to a freedom of press. The Supreme Court voted unconstitutional 6-3. They agreed that not only did it violate the New York Times' First Amendment right to a freedom of press, but also stated that the company was only doing what their founders had hoped they would do, which was find the truth and make it known to the public.